This is the Dollemore Daily.
Yes, you're watching the Dollemore Daily, but you're right, this is not Jesse. I'm Mike Greiner from the Democratic Activist channel, which we'll link to down below, and I'm sitting in while Jesse completes his move from California to the East Coast, D.C. in particular. The hope is that within a couple days he'll be back, perhaps as soon as the beginning of next week. But in the meantime, the news never stops, and today was a big day of news for President Biden, the Democrats, and everybody who's concerned about democracy in America. One of the big stories today is that the U.S. Supreme Court has struck down President Biden's vaccine mandate for large employers. This is a demonstration once again as to how partisan the U.S. Supreme Court has become. No longer is the U.S. Supreme Court a neutral arbiter who calls balls and strikes, as Chief Justice Roberts once argued. Instead, the U.S. Supreme Court has become little more than a partisan super legislative body that inserts itself into all the issues of the day and feels empowered to literally rewrite legislation that was passed by Congress. The decision, although not terribly surprising based upon how observers felt the oral arguments went the other day, is nothing short of an outrage. The statute upon which the rule was promulgated is clear. It states, and I'm quoting, "The Secretary shall provide." Shall means that it's not optional. It's something that's required of them to do. For an emergency temporary standard to take immediate effect upon publication in the Federal Register if he determines A, that employees are exposed to grave danger, number one, that certainly is COVID, and B, that such emergency standard is necessary to protect employees from such danger. Seems pretty clear. Last December 17th, the Sixth Circuit Court of Appeals seemed to agree with that analysis, writing a long and well-reasoned opinion which they clearly looked at the statutory language and found that the Secretary of Labor had complied with the statutory language in issuing this emergency temporary standard. Now, to help you understand the issues at play here, let's just take one moment to talk a little bit about administrative law in the United States. Essentially, there are two types of law that get issued by the government. One is statutory. Those are laws that get passed by Congress and signed by the president. These are obviously the elected officials tasked with representing the people of the United States. And as such, their authority comes by virtue of the fact that they are representing the people. However, Congress is unable to do everything. They can't manage the government for such an enormous and diverse country as the United States, and instead what they do is that they rely upon certain agencies, administrative agencies. Some of those agencies have leadership that are members of the president's cabinet. Others do not. In this case, the agency we're talking about is the Occupational Safety and Health Administration. This agency is part of the Department of Labor, which, as we know, is actually a cabinet-level department with the Secretary of Labor serving in the president's cabinet. Currently, the Secretary of Labor is the former mayor of Boston, Marty Walsh, who has a background working as a labor organizer. So he's a good choice. Now, the problem with this constitutional framework, though, is that the agencies are not headed by somebody who is elected by the people. So the question is, where does their authority come from to issue these rules? And rules are what they're called, by the way. And when people generally talk about so much regulation, usually they're talking about rules that are promulgated, essentially issued, put out, and enforced by the different federal agencies. Now, the authority for issuing these rules actually comes from Congress. Congress has done two things. Number one, they've passed something called the Administrative Procedures Act. And what that does is it establishes a process by which agencies need to go through to promulgate rules. Typically, those procedures include proposing a rule, and that rule needs to be published. Generally, they're published in something called the Federal Register, which is a thick book that's put out almost every single day with different rules and information that the government needs to inform people about. Once a rule has been announced in the Federal Register, there's a comment period where essentially anybody who's interested in it is able to submit comments and essentially argue before the agency as to why that rule should go into effect, why it should not go into effect, or why it should be changed. This, by the way, is where a lot of lobbying takes place. And in fact, research has shown that more lobbying money is spent addressing the process of administrative rulemaking than is actually spent on the process of legislating in Congress. This process can be long and difficult to accomplish. And what's more is any rule that gets promulgated through this process needs to be based on a separate piece of legislation, essentially a piece of legislation that gives the agency the power to issue a specific rule. Now, in this case, we have the Occupational Safety and Health Act, Title 29 of the U.S. Code, and the section that deals with setting standards and rules, which again are then enforced by the agency as well, is Section 655. And specifically, the part of that statute that authorizes the Secretary to issue an emergency temporary standard is Section 655C. Now, as the Sixth Circuit Court of Appeals pointed out, this emergency temporary standard is not some rule that stays in effect permanently or that replaces the promulgation process that includes the notice and period of comment that administrative agencies are typically required to go through. Instead, what it does is it allows the rule to go into effect while the agency is going through the process of notice and getting comment. And again, to bring this section into effect, the Secretary of Labor, in proposing this emergency temporary standard, needs to make it clear that the standard is required as a result of those two concerns. Again, them being that the employees are exposed to grave danger and that such emergency standard is necessary to protect employees from such danger. Now, to me, and to the Sixth Circuit Court of Appeals, the language is pretty clear. The Secretary has this authority, and of course the Secretary works for the President, so if the President directs the Secretary to issue an emergency temporary standard, well, the Secretary is going to do that, and Congress is clearly, in the Occupational Safety and Health Act, given the Secretary that authority. Furthermore, the Secretary of Labor has followed the procedural requirements that are stated in OSHA and has published the emergency temporary standard in the Federal Register, making it clear that it is required to be in immediate effect as a result of these two concerns. So in my opinion, and in the opinion of the Sixth Circuit Court of Appeals, the law is clear. The Secretary has this power. The President works for the Secretary. The President can issue this emergency temporary standard, and it should be binding while it goes through the typical rulemaking process. Now, to be fair, such an emergency temporary standard has never been issued. Now, as the Sixth Circuit pointed out, this makes sense, given the fact that the COVID-19 pandemic is unprecedented. So unprecedented steps are likely what need to be taken in response to this crisis. As the court wrote, and I'm quoting again, the COVID-19 pandemic has wreaked havoc across America, leading to the loss of over 800,000 lives, shutting down workplaces and jobs across the country, and threatening our economy. Throughout, American employees have been trying to survive financially and hoping to find a way to return to their jobs. Despite access to vaccines and better testing, however, the virus rages on, mutating into different variants and posing new risks. This is the crisis that the administration has stepped into to try to address. Now, at the same time as the Sixth Circuit Court of Appeals, based in Cincinnati, was considering the issue and issuing this opinion that allowed the president's vaccine mandate to go into effect, the Fifth Circuit Court of Appeals, based in New Orleans and covering Texas, for example, ruled the opposite way, stating that the president had overstepped his authority in issuing this standard. Now, this is a big claim that conservatives make, by the way, which is that these government agencies interfere in the lives of individuals and businesses, making their lives harder, and that they do so outside of the reach of the people who elected anybody. Now, I find this argument rich, in that, at the same time, we have the Fifth Circuit Court of Appeals and the U.S. Supreme Court, for that matter, stepping in and essentially acting as super legislative bodies, changing laws that were passed by Congress and by state legislators, essentially by the people who were elected, while the judges and justices stand there in their lifetime appointments, completely insulated from public opinion. And insulated they are. According to a poll last month from Morning Consult, 68% of Americans support a vaccine mandate, and other measures to address the virus, including strengthening ventilation systems, imposing travel restrictions, mandatory mask usage, and encouraging COVID-19 booster shots, all achieve 70 to 81% approval rates. So the Supreme Court has shown once again that it is a minoritarian institution representing a small group of Americans who are obsessed with the MAGA cult and who want to stand in the way of any efforts of the Biden administration to succeed, no matter what harm it does to the country. Now, interestingly enough, there were two parts of this ruling. One part rejected the Biden administration's attempt to impose the vaccine mandate on large businesses across the country. Now, let me just take 1 second here, by the way. Contrary to how it's presented, the vaccine mandate actually does not require anyone to get vaccinated. Rather, what the ETS does, the Emergency Temporary Standard does, is it allows covered employers, essentially employers with 100 or more employees, to determine for themselves how best to minimize the risk of contracting COVID-19 in their workplaces. For example, employers could require unvaccinated workers to wear a mask on the job and get tested weekly. They could also allow their workers to do their jobs from home, and workers who work outside are exempt. It's up to the employer to choose if the easiest way to address this concern is through a vaccine mandate of their employees, which, by the way, many employers have done, including Fox News, by the way. So that vaccine mandate or mask mandate, whatever you want to call it, that mandate from the administration, that has been struck down. At the same time, though, there's another rule that was proposed under different authority, and what this has to do with are healthcare facilities that receive Medicare funds. Such facilities under this rule would also be required to have some type of vaccine mandate. Now there, I can't even believe that there's any controversy. The federal government routinely will attach strings to money that it gives to the states. When the federal government will, for example, provide funds for the interstate highway system, they will attach certain requirements to the states. For example, that the state needs to pay a certain portion of it. When they provide education grants through the Department of Education, those will routinely have certain reporting requirements attached to them. So it is standard practice for the government to attach strings and requirements to monies that it gives to the states. And that's all it was doing here, is essentially saying, hey, if you accept federal money, then you need to comply with these rules. And as a result, by the way, organizations have a way out. They just have to say, hey, we're not going to take the federal money, so we're going to do whatever we want. It's the equivalent of, for example, public schools, which are restricted, or at least have been up until the Supreme Court started its recent reign of terror, which have been restricted in their ability to teach religion. If a school wants to teach religion, it can do that. It just can't receive public funds. So what's shocking, though, about this other part of the decision, the part where the Supreme Court ruled that that rule could go into effect, is that that ruling was by 5-4. That you still had 4 members of the Supreme Court saying that the federal government can't even tell organizations that receive federal funds that they're required to have a vaccine mandate if they're going to receive those federal funds. Now, those 4 justices shouldn't surprise anybody. They were, of course, Thomas and Alito, who've become the leaders of the far-right MAGA crowd on the court. And then, of course, Gorsuch, who sits in the seat that was stolen by Mitch McConnell from President Barack Obama. And finally, Justice Barrett, who was appointed by President Trump just days before the last presidential election, after Republicans had pledged that they wouldn't do that. These 4 have clearly become nothing more than a partisan right-wing cabal who are intent on rewriting the laws and doing so to do damage to the Biden administration, no matter what harm it does to the rest of the country. If there was any doubt that the Supreme Court has become nothing more than a partisan legislative body, those doubts should be gone from people's minds at this point. Well, if you agree with me or disagree with me, have any comments or questions about this, please feel free to leave them below. And if you could check out my channel, Democratic Activist, we'll also link to that down below. I'll see you in the next video. In the meantime, let's hope for continued progress. Thank you.